Hello, everyone. Thank you for joining us today. My name's Ange Valentini, and I'm an engagement consultant working with the British Columbia Law Institute. A few housekeeping items for today's session. BCLI is recording today's session and will be posting the recording online for people who are not able to join us live today. Please feel free to turn your camera off if you do not wish to be included in the recording. Throughout the session, we'll be posting information and links in the chat. We encourage you to use your emojis and the chat to share your feedback and any questions you may have. As we get started today, I want to acknowledge that we're hosting today's virtual town hall on the unceded and traditional territories of the Musqueam, Squamish, and Tsleil-Waututh First Nations. We are honored to live, work, and be in relation with people from across many traditional and unceded territories covering all regions of British Columbia. We're also honored to live on this land and are committed to reconciliation, decolonization, and building relationships in our communities. The British Columbia Law Institute is a not-for-profit law reform agency. BCLI's work is centered in scholarly research and analysis of existing laws to determine pathways for law reform. And the goal of this work is to provide clear and actionable insight to government and decision makers to improve laws in British Columbia. We have a really impressive team joining us today for this virtual town hall. Today you'll hear from Barbara Finley, KC, Kevin Zakreski, and Allison Wilkinson. So right now I'd like to take a moment to introduce Allison Wilkinson, a staff lawyer with the BCLI team, to get us started.
Thanks, Ange. And thanks to everybody who is here with us today. So I'd like to start by providing some background information on the project and why BCLI has undertaken this work. The Family Law Act was brought into force in BC in 2013, and this law really created the first framework for parentage in BC. Part 3 of the Family Law Act sets out the legal definition of who is considered a parent. At the time, it was innovative and really sought to capture individuals who were falling through the cracks. This was especially with developments occurring in assisted reproduction. But it's been 10 years since the Act came into force, and the Attorney General asked for BCLI's support in considering the law and whether it's still working for British Columbians. With BCLI, we're an independent law reform body, so we really have specialized tools and knowledge to consider legislative change. We have a multi-step process. This includes engaging with an expert committee to create tentative recommendations, seeking public consultation on these tentative recommendations, which of course is what we're doing right now for this project, and then finally creating a final report, which incorporates the expert guidance with public feedback. So why parentage? Determining who a child's parents are is an important part of family law. It's the foundation of many aspects of a child's identity, such as family name, relationships, roles, and decision-making rights. Parentage can also determine important things such as inheritance rights. Over the past decade, there's been considerable developments in law, society, fertility services, all of which change the ways that people are building and expanding their families. The Parentage Law Reform Project has examined whether Part 3 continues to address children and parents equally, protecting children's best interests, and supporting the diversity of ways that people create families. Okay, so I'm just going to provide a little bit of insight into how we work and who we work with, specifically the project committees. So when we initiate a law reform project, BCLI starts by listing issues that need to be considered. And this is really stage 1 of the project. So these issues are then researched by BCLI staff to provide background and options for the committee to then consider. Often this includes looking at law reform in other provinces or considering important cases that are tackling this issue. So a committee of subject matter experts then deliberates on the topics.
Are you depositing it or am I?
I can try.
Oh, we got to put it.
Sorry, I think I can hear someone else talking.
If we can
Sorry.
just ask everyone to mute, that would be awesome. Thank you.
All right, I'll just jump back in. Thank you. Okay, so once we've outlined these issues, our committee of subject matter experts deliberates on the different topics, and then we craft tentative recommendations from there. So, what is the purpose of engaging with experts? Well, there's two main reasons. First is we want to hear from a range of voices, professions, and perspectives to ensure that recommendations work not just for lawyers, but for other professionals who engage with fertility, family building, and parentage more generally. Second, we want to make sure that our work is guided by experience and expertise. So we have the incredible privilege of working with lawyers, doctors, advocates, scholars, counselors, all of who have a wealth of knowledge in this area. They bring to the table not only their own expertise, but also the experiences of their clients. These people are passionate about making recommendations that work for real people and solve real problems. We're so fortunate to have some committee members with us here today, and you'll be hearing from them shortly. We have a full list of our project committee on our website. Sorry, next slide, Ange, if you could. Thank you. So stage 2 of the project is public consultation, and that's the stage that we're at right now. So legislation impacts the lives of British Columbians, and this is why a key piece of law reform is talking with the public. Once our expert committee has completed consideration of the issues and crafted tentative recommendations, we create a consultation paper for public consideration. We then go out into the community and we ask for feedback, and that's exactly why we're here today. The consultation paper contains 34 tentative recommendations for reform. The tentative recommendations address a broad range of issues. However, some general buckets include diversity and inclusion, decreasing barriers and costs associated with family building, and also changes intended to streamline and clarify. So we're going to explore just a couple of the questions that the committee raised in each of these categories. So you'll see here on the slide, there's a number of different questions. I'm just going to sort of do a high level discussion. Many of the tentative recommendations consider different family models and different ways of building a family. So for example, something as basic as the language of the Act. Many other provinces have begun moving towards gender neutral language. Using gender terms, it makes assumptions about people, their bodies, and their identities. By using descriptive language, like person who gave birth to the child, we can be more inclusive and we can ensure that the law is capturing all different kinds of people who give birth. Another piece is around the number of parents. So again, this is an area that other provinces have begun to reform. In BC, we already had a provision allowing for more than 2 parents. However, the committee felt that we could move to create even more freedom for people to build families as they saw fit. Our committee has been incredibly passionate about reflecting the lived experiences of their clients and making tentative recommendations that capture the full range of British Columbians. Another aspect was tackling issues that have come up specifically in litigation over the past 10 years. So some of these are really just simple tweaks that answer questions in the legislation rather than having to go through court, which can be, of course, quite timely and expensive. Sorry, bear with me here for a second. Finally, creating a family can be extremely time consuming, expensive, and challenging for some British Columbians. For people who need or choose to use assisted reproduction, there are a lot of hoops and costs associated with it. A large piece of the committee's work was considering how to increase accessibility. Fairness means that becoming a parent should not be dictated by your socioeconomic status. So one example of this was sperm donation by sexual intercourse. This allows parties to use sexual intercourse as a method of conception so that they can avoid the costs of assisted reproduction. This increases accessibility. However, it was balanced with the safeguard of requiring an agreement. This is the model adopted by other Canadian provinces as well. These are just a few of the tentative recommendations we have considered. As I mentioned, there's 34 of them. So this is just a couple for people to look at and consider. And with that, thank you so much for your attention, and I will turn it back to Ange.
And I'll find my mute button and come back to you all. Thanks so much for that overview, Allison. I understand that the committee has made 34 recommendations, which are all detailed in the consultation paper. And that's available online. And we do encourage all of you joining us today to review the full report. And there's a link to it right in the chat if you're looking for it. And now I'd like to take this opportunity to invite Barbara Finley and Kevin Zakreski to join us in conversation to share their perspectives on this important work. Barbara Finley, King's Counsel, is a Vancouver-based lawyer who is one of the co-founders of Fertility Law BC. And since her call to the bar, Finley has been at the forefront of advancing intersectional feminist perspectives in law. Her practice specializes in family law for LGBTQ families and child custody cases. You can learn more about Barbara and her work in the chat. And we're also joined today by Kevin Zakreski. Kevin is a staff lawyer with BCLI and has been a key member of the law reform team for more than 20 years. He's supported expert project committees and produced recommendations for a range of topics from not-for-profit organizations and evidence, as well as wills and estates and family law and more. You can find out more about Kevin's work in the chat as well. And I am going to stop sharing and bring Kevin and Barbara up front. There we go, a spotlight. Welcome. There we go. And wonderful. I'm going to start by asking Barbara a question. My screen is stuck. Barbara, there's a number of issues that the committee has addressed, and I had the privilege of attending a few committee meetings where you spoke very passionately about why these changes are so critically important for families in British Columbia. And I'm wondering if you could just talk to us a little bit about your role on the committee and what really stands out for you as some of the critical work here.
Thanks. I was very honored to be a part of this committee. I'm old now. 35 years ago, when I was practicing family law for queer and trans folk in BC, there were literally no protections. 25% of the laws of the province actively discriminated against queer folks. If a lesbian couple had a child together and then broke up, the law recognized only the parental rights of the woman who had birthed the child, and the co-parent was literally a stranger in the law. From there, I've had really exciting opportunities to work with a variety of different ways that people have chosen and are choosing to create families and to it's an odd thing, you know, when you are outside the law to see the creativity and the ways in which people think about what is a family and how do we create a family. And what I took away from that, and what I'm really, really happy to see and captured in the deliberations of this committee, is that it's not a genetic connection that makes a family. It's the intention of creating a family. And that question, you know, 50 years ago, that question didn't even get asked, and your parents were the parents who had sexual intercourse and conceived you, and the only question was, did the birthing mom include the name of the man with whom she had conceived the child or not? These days, that's an infinitely more complex question because of assisted reproductive technology that enables any family to conceive a child either with genetic material from one or more of the people who are the intended parents, or from genetic material that is genetically unconnected to anybody. So that the really important piece, I think, foundational piece for this regime, is that it's founded continues to be founded on the idea that the parents of a child are the people who, when the child was conceived, intended to be the child's parents. And that's who goes on the birth certificate. That's maybe the most important, exciting thing for me. And it is a continuation of some of the ideas that have been in the Family Law Act for the last 10 years.
That's a really insightful summary, Barbara. Thanks. Kevin, you have worked with a lot of expert committees, and you were a key part of this work. Are there some things that stand out for you from your perspective that you think are really important to highlight for today's discussion? And just before you answer that question, I want to encourage everyone who's attending today, if you have questions for Barbara or Kevin, please put them in the chat. Let us know, and I'll be happy to direct your questions to the team. Thanks, Kevin. Go ahead.
Yeah, thank you, Ange, and thank you to everyone who has attended today. As Ange mentioned, I'm not a committee member. I'm a staff member with BCLI, and I've been privileged to be with this project since its inception in the sort of shadow of the first part of the COVID-19 pandemic back in 2020, which is when we were approached by the Ministry of Attorney General to take on a project reviewing Part 3. We knew it would be a challenging project to take on. I think we may not have grasped the full complexity of it. And I've been very grateful to work with our committee, with committee members like Barbara, who've come along with us on this journey of, and I checked before we started this session, it's been 30 committee meetings that we've done since the very end of, I think the first meeting was in December of 2020. And the committee's commitment really to ensuring that the recommendations we make, bring British Columbia's law on parentage up to the current day as best we can. It's always a challenge in this area because the law is, I think, constantly trying to catch up to, advancements in technology and medicine, as Barbara mentioned. Assisted human reproduction continues to develop and outpace the law, and changes in social attitudes. And I think we've seen that just over the past 20 years that I think society has a more open sense of what makes up a family now than we, I think, did at the start of this century. And, the law moves very slowly and it's always trying to play catch up. And particularly areas of the law like parentage, which it's sort of a curious mixture. It's a fundamental status. It's often described as the foundation for things that, that are built upon it in other parts of our family law. So it's an important part of the law, but ideally it should work in a way that's, unobtrusive and really supports people in building their families without them even having to take notice of it. And to make that work, the law needs to be inclusive, and probably more than that, it really needs to be comprehensive. It would really have to make sure that parentage works for all children in British Columbia. And that's really an exercise, as our committee has found out, in careful deliberation and examination of some very fast-moving developments in technology and social circumstances. And I think, to bring it back to our consultation paper, I think if you've had a chance to look at it, you can see the full depth of the committee's deliberations on these points. And we're not done yet because we have not finally made up our mind on our recommendations. So this consultation process is, as Allison pointed out, an important building block in getting to those final recommendations. because it can bring out, new ideas, developments on our ideas that we weren't able to consider.
So one of the things I just like to notice on the way by, Kevin, as you speak is, so what we were talking about when we talk about parentage, we're not talking about parenting. So parentage is who goes on the birth certificate, basically. And parenting is once a child is born, who's going to participate in raising that child. And those are different questions. So we were looking at who's going to be on the birth certificate. And I think one of the big successes in the way that our committee worked together, first of all, there was a very diverse committee. It had medical people, it had legal people, it had people from very many different communities who are affected by the changes we were going to make. And our kind of very early on, we realized that we couldn't start thinking about these questions by looking at what was in the legislation the last time, because if anybody was going to be left out, you wouldn't know that by reading the section of the legislation. Instead, we had to start thinking about the questions from the perspective of the many different family forms who already exist and who might in the future exist. And then think back to the law, back to what the legislation was written, to see whether those families were adequately included and described in the legislation. So our recommendations, I think, have, I mean, we may hear, I'm hoping actually that we'll hear from people who say, oh no, you forgot something, because that will mean that the consultation process has worked well. But with, maybe we took into consideration all of the family forms that we might need to have been thinking about.
That's really great perspective, Barbara. I just one of our participants in the chat has dropped in a question. Could the committee say a little bit more about the rationale to include sexual intercourse as a way to provide genetic material? Specifically, I'm not convinced that it's reducing the costs. At-home insemination is not really expensive, and I am concerned that we're overlooking specific vulnerabilities. That's one question that's in the chat.
Why don't you start, Kevin?
I was going to actually ask for your thoughts, Barbara, but I'm happy to start us off. Because I think the question is right. That was one of the key driving factors, is particularly around our recommendations on sperm donation by sexual intercourse, that we did have an appreciation that it was likely cheaper to use that model. I think there was some awareness that you could use what's colloquially called the turkey baster method to achieve a kind of assisted reproduction that's maybe similar in approach, but it's practically probably not as effective. I think we also, sort of stepping back and philosophically, I think one of the things we appreciated, British Columbia was sort of a leader when it came out with the Family Law Act in recognizing assisted human reproduction and its role in parentage, but it arrived at a very rigid separation in its legislation. Essentially was saying we're going to have this set of rules for sexual intercourse, children conceived by sexual intercourse, and this other set of rules for children conceived by assisted human reproduction. And sort of one of the benefits of our committee is coming along after that decision was made, we could look at what other jurisdictions, particularly other provinces in Canada, have done. And they've taken a markedly different approach to that. They've allowed some flexibility around tailoring some of the insights that we were able to draw from the experience of assisted human reproduction. And Barbara touched on the most important philosophical insight, which is that you can build families by intention. And one of the major things this committee was able to do was to start thinking through how that insight can now be applied back to these children who are conceived by sexual intercourse. And I think there was a fundamental decision. I'm going to turn it back to you, Barbara, but I think one last thing I'll say is there was a fundamental decision, and I remember you being strongly an advocate for this, was in dealing with the vulnerabilities and the trade-offs that may apply in making that decision. It was best not to try to tailor the regime in a kind of a narrow way, but rather to rely on things like legal advice, things like requiring a written agreement to give evidence of intention, which does add some costs. It does add some time, but we thought arrived at an area where you can combine some of the certainty and protection that you're not sweeping vulnerable people in, but yet you're extending this regime in a way that may benefit other people.
Thanks, Kevin. So the issue was this. On the one hand, we know about children conceived with sexual intercourse. That's pretty straightforward. Over here, on the other hand, we know about children who are conceived with assisted human reproduction, and where sperm is the donated gamete, then the question is, how does the sperm get transmitted into the body of the person who's going to give birth? And there's two different ways, really. I guess three different ways. One is insemination at a clinic, one is home insemination, and one is sexual intercourse. So the question really for the committee kind of turned around to, why would we not permit children who are being, I'm being inarticulate here, where the sperm is going to be donated? Why would we say that cannot be through sexual intercourse? If we are concerned to protect the parties, then that concern, a perfectly valid one, is met by requiring, as we do, a written agreement ahead of time that says this sexual intercourse is intended as a sperm donation. And with that document, that agreement made, of course, before the intercourse occurs, then you have something that's really indistinguishable from the what Kevin called the turkey baster method, except that intercourse is involved, whereas in the turkey baster method, it is not. So it's not to the person who asked the question, it wasn't really a matter of why would we do that so much as a matter, for me anyway, of why would we not? Why would we not offer the broadest range of possibilities to people who are looking to use the most effective way of getting pregnant in combination with their intention about who the parents of the child would be at the end of the day?
With everyone's permission, Regine asked the question and has their hand up. So Regine, can I just invite you to turn on your mic?
Yes, is it okay to go with a follow-up in terms of process? I don't want to take too much of your time or to do things that I'm not supposed to do in the context of the townhouse. Can I follow up?
Follow up myself.
Okay, so thank you so much. If I may, I'm sure that you've had very complex conversations about this. If I may ask, try to voice a different opinion, framing exactly the way you did it. So why would we not? And I would like to offer maybe 3 reasons that may or may not be valid, but just to express a different view. So my research in the field shows that, especially in Quebec, where it has been allowed to contribute via sexual intercourse, the uptake in queer family is very low. So there is very little empirical evidence as to whether or not, especially in the context of lesbian couples and single women, in which sexual intercourse was actually used to create the family. So that's one reason. The second reason is that we have testimony evidence in which especially single women by choice and lesbian women were actually pressured into having sexual contact that were undesired with the donor, that led to the breakdown of the donor relationship between the parties, but also to, I think, attempt, I think that it's really
Can I just ask, who was pressuring whom?
so the donor
Yeah,
was pressuring when the home insemination was about to happen, the person that would receive the sperm, telling them it would be easier, it did not work well, can I touch you in that way? And we also, there's actually a documentary about that that I'm happy to share, in which we have the testimonies of this woman, and some of them were actually pressured. One of them was actually pressured into having a full sexual relationship that actually did not lead to the conception of a child. So that's something that I want.
so basically the donor is saying, I'll donate sperm, but only if you have sex with me.
Well, the situation is a bit more complicated. So it was in an ongoing relationship, and when the moment happened to donate, the donor put pressure in that very moment to so, but you know, the donor relationship, it's not a one thing situation. You often have to try, you have a relational aspect going on. So that's something else that I wanted to put out there. And the third one is more theoretical, but it does seem, while it is indeed expanding the ways in which we are welcoming family under the statute, is that does seem to me as a profoundly heteronormative framework for thinking about sexuality, as sexual intercourse leading to the conception of children. So it's a very narrow understanding, I do think, of the sexuality, especially of queer women, to be, I just think that from a theoretical perspective, it is relying on what we understand as key sexuality, which is very heteronormative. And I would just wanted to put that out there.
That's really interesting. Starting with your last point first. In my practice, I actually would completely agree that the number of lesbian women looking to become pregnant who would choose sexual intercourse as the way to do that is pretty small, because we're lesbians. However, I know in my practice I've seen it happen. So I've seen lesbian parents to make that choice. Now, so then your second choice, I think, related to the power imbalance potentially between the sperm donor and the recipient. And I certainly recognize that that's power imbalance between women and men is always fraught, or between men and non-binary people, for example, that moment of conception offers an opportunity for exploitation. And I think it's a really interesting question where the balance is in terms of, and it's a question that we actually had to struggle with in several different locations, how do we trade off protecting from exploitation on the one hand and offering as much choice for consenting participants on the other. So I really am grateful for the question. And if in my comments I've misconstrued the questions, let me know.
Thanks so much, Barbara. I think that was a really thoughtful response. And Regine, it was also a very thoughtful question, and I appreciate you raising it. And I know I went off the process a little bit by sharing the mic, but I feel like we were able to get the real spirit and intent of your question by hearing your voice. So thank you for bringing that voice. And I think you really highlighted the key question here about why the public consultation process is so critically important to having a fulsome discourse and providing solid recommendations going forward. Kevin, I would love to hear from you if you have anything you want to add at this point.
On that last set of questions, or just in general?
Well, I was really thinking about maybe about the myriad of perspectives that need to be weighed and considered in the deliberative process when contemplating law reform, and particularly how it relates to this set of consultation that's open right now.
Yeah, thanks. And I agree with you, Ange. I think this discussion, helpfully illustrates the fact that there are many valid perspectives on these issues, and more than that, many different philosophical approaches to it. We did, as Barbara said, and I endorse her comments, we did wrestle with this point repeatedly in the project, the tension between essentially expanding the law of parentage to embrace new and unfamiliar forms of building families, with the possibility that might, leave vulnerable participants in these projects to build families more vulnerable to exploitation. And generally, I would say, as Barbara pointed out, as a philosophical matter, we tried to grapple with that less by taking a restrictive view of what the law of parentage could do, and more by looking at some sort of advanced remedial measures, like requiring agreements, like requiring legal advice, as a way to expand the reach of parentage law. And it, I guess, goes back to that fundamental point of, if parentage law is going to work the way it needs to, it really needs to be comprehensive, and it really needs to cover all children.
I'd be interested, Regine, if you don't mind answering this question. Do you think that some of the concerns that you raised are addressed by our requirement that before you can use sexual intercourse as a way for conceiving, you must have a written agreement that's ahead of time, so that the choice point is not at the time of intercourse, it's some while before that in a lawyer's office, maybe?
I do think that it is independent legal advice and agreement before conception are probably the safest measures, assuming that so I do find that it is a good compromise in a way. I, however, have concerns that people might not follow the law or not be aware of the law, or that might be afraid of the extra costs that this is going to lead to. So I do think that in theory, it is an important and great safeguard, and I do see where the committee is coming from, and I want to acknowledge that. In practice, I am not sure how it's going to unfold in terms of education, public education, in terms of whether people follow the law, and in terms of the actual extra cost that this is going to lead to. I'm also absolutely respectful of the committee's perspective on the matter and your reflection. And so I thank you for asking you my thoughts about that. And I hope that I'm presenting this in a very respectful and constructive and productive way.
Oh, absolutely. And your comments just now made me think of a different thing, which is kind of it kind of goes against what I was saying earlier. And that is the afterthought. I mean, we require written agreements before this happens, but what about the situation where after intercourse has occurred, one of the participants says to the other, so that was our assistant, that was our ART, and you're not a parent, and the other one says, no, that's not what I thought. And then can you kind of undo that misconception, if you'll pardon the pun, and by going to court and saying, which is it? Can we cure the lack of a written agreement by evidence about the party's intention, et cetera, Maybe it is so fraught and so incapable of being dialed back after the fact that we should just leave out that method of assisted human reproduction altogether. So thank you for the conversation, because it has made me think different thoughts than I had thought before.
I appreciate that, Barbara, that you're embracing the dialogue and the conversation. And Regine, thanks for showing us, validating our views that the consultation part of this process is so important to getting to the right recommendations. Barbara, I just want to give you one more opportunity as a longstanding advocate for families who've been excluded in the past, including trans and non-binary folks and folks with poly or multiple parent families and others. Is there anything else you want to highlight today about the changes you see as critically important to these families in this paper? And I'm really struck by the point that you've raised already, that it's the intention that builds families. And I think that's powerful. But just if there's anything else you'd like us to think about as we go away and think about our thoughts and our response to the consultation paper.
What I would say, based on the decades of doing this work, is that doing the very best we can, we will not come up with in our imaginations all of the different ways that people will find to want to create families, which include the birth certificate parentage aspect. So, 30 years ago, I wouldn't have imagined that I would be in the business of figuring out how to get more than 2 parents on a birth certificate. That was one of the other kind of, nobody thought about it assumptions. And while we were doing this deliberation in the committee, we were talking about polyfamilies, and somebody said what number of parents there should be as a maximum number of poly parents. And I said, wait a minute, you guys, I have already been there, done that. I don't want to have to go back to court and make another argument about how the statutory definition of family only includes X parents, but I have X plus 3 or whatever it is. So I actually do envision a future that is in some way a continuation of the path we're already on, and that is a future in which we continue to shape families, but we do that with much more intention, and we do that with more intention for a whole variety of reasons which are economic, which are cultural, which are geographical. People who are going to be parents and live in different places, that there are so many factors impacting that legal connection between adults and a child, that we for sure have not thought of them all. And what I do hope is that we've thought of a framework that is flexible enough and robust enough to be able to recognize those family forms as they emerge.
I think that's a really powerful sentiment and a great summary on that point, Barbara. Kevin, is there anything else at this point in the conversation that you want to highlight to our participants and to the public? Things that you really hope they'll consider when making responses to the consultative draft. And just before you answer that question, I want to let everyone know that the links for the BCLI webpage with the consultative draft, with the response booklet and the survey you can fill out are all in the chat. So Kevin, your last sales pitch to the public about why it's so important for them to share their feedback at this time.
Sure. Thank you, Ange. And thank you, Barbara. And I just want to echo that sentiment. I think that is the goal we were aiming toward. You know, you can't obviously predict the future, but I think the blueprint the committee has developed does provide a better framework for allowing, you know, that future to develop in the best possible way. I'd like to underscore the range of the committee's consultation paper. I mean, we've talked about some of the, you know, the methods of creating a family. There are a lot of tentative recommendations on the powers of the court, which is interesting because I think our approach was, and I think it's generally been British Columbia's approach, has been to downplay the court's role in determining parentage. And I think British Columbia and the committee has been right on that. I think it's, at least to my eye, it's good to see that we're not sort of routinely requiring people to go to court to get the court seal of approval on their intentions.
Yeah, for sure.
But I think the committee did take a thoughtful look at what powers Part 3 currently gives the courts, and I think has a number of improvements for, you know, just because we don't know the future, it's unpredictable. The only thing we can predict is there's likely to be conflict in the future. So sometimes parentage is going to end up in the courts, and I think the committee's got some thoughtful tentative recommendations on, you know, how to ensure if the courts do have to step in, they've got the powers they need to do that job in the best possible way. And I'll pick out a rather obscure one, or maybe not a rather obscure one. If you follow family law generally, you know, the best interests of the child is obviously a key concern. And we spent a lot of time, Barbara will remember, discussing how that may be accommodated within Part 3. And maybe a bit controversially, we've said that we don't think it's for the statute to try to acknowledge the best interests of the child. And we could get into the reasons for that. It was a complex discussion, and it seems a bit counterintuitive. In a broad kind of way, I think we would characterize what we're proposing and what parentage law is doing is acting generally in the best interests of the child. But it's tied up with a point Barbara made very early in her presentation. Parentage is not parenting a child. That's why we're often talking about what's happening before the child is born. And it's difficult to apply a decision-making framework like best interests that has a specific definition under our Family Law Act that gears it toward what specific parents are doing to raise a child when that child has not even been born yet. But as I say, that was a point that generated a lot of discussion. I think we came back to it repeatedly in meetings, and you know, we'd certainly be interested to hear any thinking around that issue, you know, in the consultation as well. So those are a couple things.
And I would say, I don't know if you would agree, Kevin, I think I would say that the kind of conceptual break the mold changes came when Part 3 was enacted and came into force in 2013. And that what we are doing this time around is not a, you know, break the egg and make a different omelet. but it's rather, I'm going to get into trouble with that simile. I can't finish that simile in a sentence, but never mind. What we're doing is looking at the experience of the last 10 years, the developments in assisted human reproduction technology, and what other folks are doing around the world, and making the current understanding, which is an intention-based system, largely an intention-based system which will operate into the future for a diverse and not closed list of family forms. And if we manage to do that, then with luck, it'll last us another 10 years.
That's a good sentiment, Barbara. Thank you so much for that. Kevin and Barbara both, I really want to thank you for your candor today and your thoughtfulness in this work and joining us in conversation. And I do want to acknowledge the work and contributions of the rest of the BCLI team, some of whom are on this call today, because it does take the whole team to get this work done, and so many valuable perspectives to create space and ensure that law reform reflects people who are often made invisible by our legal system. So
Can I just contribute onto that? I think that the quality of the work that we've done, and I'm proud of the work we've done, depended entirely on the excellence of the work that Kevin and other folks at BCLI did in supporting our conversations and deliberations. It's not like they did all the work, but they did the necessary pre-work to make sure that we were not veering off track in startling ways. And so I just really want to appreciate the BC Law Institute and its importance, because rarely does any legislation get the degree of careful attention that the BC Law Institute is able to offer when law is being changed. So for me, it's been a real honor to be part of this process.
Thanks so much, Barbara. Thank you, Barbara. Thank you, Kevin. I'm gonna take the spotlight, take you off the hot seat. I want to thank everyone who has joined in this call today. And some of you have written in the chat. I know that a number of responses have already been received to the public consultation. I hope that this conversation has given you all food for thought. And if you have additional thoughts to offer through the process, please follow the links in the chat and check out the website. There's 366 pages in that consultative draft, so there's a lot to reflect on. And at this point, I'm going to invite Allison Wilkinson back, our staff lawyer, to tell us what's next. The consultation closes in a few days, and Allison can tell us what happens next in the process. I'm going to find Allison on the screen. There we go.
Great. Thanks so much, Ange. And thank you to everyone who attended today. And of course, Kevin and Barbara. As Ange mentioned, there's a couple days left to provide feedback through our website, and we have a couple of different ways to do that. I believe the links are in the chat for anyone who's interested. In terms of what comes next on our side with our process, essentially once we obtain feedback from the general public, then our project committee will again meet, and we're going to consider and incorporate the public's feedback in creating our finalized recommendations for reform. You notice that we've been calling them tentative recommendations, and once we incorporate the public's feedback, then they become our final recommendations. Once this is complete, then we release a final report containing all of this information, and the document will be available on our website for free, and it can provide guidance and information to government organizations and individuals who are interested in this work. Again, we're just so grateful for everyone who attended today. Public consultation is so important to our work, and we really value every voice and perspective. And just a final thank you, and everyone enjoy the rest of your day.
Thanks, everyone. Have a great afternoon.